Hi, my name is Arpita Bajpayee. I'm originally from Ottawa, Ontario, part of Algonquin land, and today I'm going to be reading Civil Litigation, which is pages 166 to 167 of the July 23rd version of the TRC report for the Read the TRC project. Having generally failed to find justice through police investigations and criminal prosecutions, residential school survivors increasingly turned to the civil justice system in the 1990s, bringing lawsuits against abusers as well as the federal government and the churches that operated the schools. The Canadian legal system, however, was prepared to consider only some of the harms that survivors suffered, generally those harms caused by sexual and sometimes physical abuse. It refused to consider on the merits of the survivors' claims relating to loss of language, culture, family attachment, and violation of treaty rights to education. The Canadian legal system refused to consider the claims that survivors brought on behalf of their parents and their children. It also refused to provide remedies for the collective harms that residential schools caused to Aboriginal nations and communities. Residential school litigation has been extremely complex, expensive, and lengthy. It has been especially hard for the survivors, many of whom were re-victimized through the explicit questioning and adversarial treatment by the Government of Canada, the churches, and even their own lawyers. Limitation period. Within the Canadian justice system, complainants in civil proceedings have a limited period of time in which to file suit. If they wait too long after the harm they have suffered, they may not be allowed to pursue their claim because of a provincial statute of limitation. Although statutes of limitation can protect defendants in civil lawsuits, they can also have the effect of denying plaintiffs the opportunity to have the truths of their allegation determined in court. This is most dramatically true for child victims who have neither the means nor the knowledge to pursue claims of harm until much later, when the time period for a claim may very well have run out. A statute of limitation defense has to be raised by the defendant. In its 2000 report on responding to child abuse in institutions, the Law Commission of Canada recommended that the federal government should not rely solely on statute of limitation defenses. Nevertheless, the Government of Canada and the churches have frequently and successfully raised these defenses in residential school litigation. The Commission believes that the federal government's successful use of statute of limitation defenses has meant that Canadian courts and Canadians in general have considered only a small part of the harms of residential schools, mostly those caused by sexual abuse. Some provinces have amended their limitation statutes to enable civil prosecution for a wider range of offenses. We urge others to follow suit. Call to action, number 26. We call upon the federal, provincial, and territorial governments to review and amend their respective statutes of limitation to ensure that they conform with the principle that governments and other entities cannot rely solely on limitation defenses to defend legal action of historical abuse brought by Aboriginal people. Thank you for listening.